Hey you guys, if you haven't heard by now, the Crown Act has been passed by the House of Representatives. Yay! Yay! But wait, it still has to go through the Senate. If you're not familiar with the Crown Act, it is a law that will ban corporations and educational institutions from discriminating against black people and people of color that wear their hairs in afro texture styles, wear their hair in braids, locks, dreads, whatever you like to call them, twists, and different things like that. Anything, any style or anything that is deemed culturally black. I also speak about hair discrimination in depth in my video, Is Hair Discrimination Still a Thing? And be sure to check that out because it is still a thing and we're still dealing with it. That is exactly why we're still having this conversation. And unfortunately, there are people out there that do not feel it's important for black people to have the right to wear their hair how it is. They will talk about everything in the world as if it's not our own human right to be who we are. So what I'm going to do for you, I'm going to leave a clip of my video within this video that describes the Crown, partially describes the Crown Act. I'm also going to leave a clip of the debate that the House had prior to deciding to pass the bill. And you will see, it will be just a small clip. I will also leave the link to the whole debate so if you all would like to see the whole thing. So let me know what you think. Do you think the Crown Act is important or do you think it's not that serious? Have you ever experienced any hair discrimination? Let me know in the comments. And also be sure to subscribe, share, like, and check out the video, Is Hair Discrimination Still a Thing? Until then, see you next time. Bye. Natural hair. So then in 2019 we have the Crown Act, which is an acronym for Create a Respectful and Open Workplace for Natural Hair. So California is the first state to actually pass this law. And New York became second with New York's Assemblywoman Tremaine Wright working along with them. So New York was second in line and they passed the law as well. So this law was to legally protect black students and employees, to protect their hair and how we wear our hair. So I'm gonna read a little bit of what it consists of. It states that the history of our nation is riddled with laws and societal norms that equated blackness and the associated physical traits. For an example, dark skin, kinky, and curly hair to a badge of inferiority, sometimes subject to separate and unequal treatment. This idea also permitted societal understanding of professionalism. Professionalism was and still is closely linked to European features and mannerisms, which entails that those who do not naturally fall into Eurocentric norms must alter their appearances, sometimes drastically and permanently, in order to be deemed professional. Despite the great strides of American society and laws have been made to reverse the racist ideology that black traits are inferior. Hair remains a rampant source of racial discrimination with serious economic and health consequences, especially for black individuals. Workplace dress code and grooming policies that prohibit natural hair, including afros, braids, twists, and locks, have a disparate impact on black individuals, as these policies are more likely to deter black applicants and burden or punish black employees than any other group. So that's a little part of what is in the Crown Act. I will also leave that.
And the inflation rate creeps higher, and the folks willing to enter into jobs seem to be less and less, and the catastrophes keep coming. But this is the top priority. I don't think we need to drive lawsuits between Americans. I think in the main, Americans well understand the rules of the road. As the Judiciary Committee itself reports, courts have generally even recognized that hairstyle, to the extent it's associated with race, as a basis for decisions on employment or the like, is already unlawful. The EEOC's own manual says that discriminating on the basis of, for example, afros is unlawful. Another solution to a problem that doesn't exist in any significant scope in this country, and the result being inflation that gets higher, more supply constriction that drives inflation higher, more animosity and obstacles between employees and employers, between merchants and customers, to drive more lawsuits, to pay more lawyers, to make the quality of life in America so much better. That's where we are. That's where we are today on the floor of the House. I yield back.
The gentleman from Ohio reserves. The gentleman from New York, Mr. Nadler, is recognized.
Madam Speaker, I would point out again, because some of my Republican colleagues seem not to hear it, that this is the law, as they say, but that several circuit courts say it isn't the law. So all this bill is doing is reaffirming what the law is, despite several circuit courts. And we see that the law in those states where the circuit courts have upheld it properly has not resulted in any of the catastrophes we just heard. Madam Speaker, I now yield to...
Yield?
Yes, I will.
Is it not correct, Mr. Chairman, the reason this bill is on the floor is because Republicans voted against a suspension,
Yes.
which could have easily passed to say we're against discrimination. And because 188 Republicans voted no, this bill needed to come forward. Because, as the chairman has just pointed out, the law is in doubt because courts have taken different positions. I thank the chairman for yielding.
I thank the gentleman. I now yield 2 minutes to the gentlelady from California, Ms. Lee.
Thank you, Madam Speaker. I rise in strong support of H.R. 2116, the Creating a Respectful and Open World for Natural Hair Act, commonly known as the Crown Act. And I'd like to thank Speaker Pelosi, Chairman Nadler, and of course, Congresswoman Bonnie Watson-Coleman for bringing this bill to the floor. And let me just first say, we all know, and you've heard the debate, that this bill is going to take aim at prohibiting race-based hair discrimination. But let me just tell the other side, I am an American, and it is very important to me and to millions of Americans. Yet, your arguments, they're outrageous, but they're not surprising that Republicans, every step of the way, try to diminish the humanity of black and brown people, try to uphold white supremacy at every step of the way. Just listen to what you're saying in terms of arguing against this bill. For decades, black and brown people have been penalized for wearing hairstyles, natural hairstyles, deemed as messy, unruly, and unprofessional. We've seen students humiliated and unfairly disciplined because their braided hair extensions or locks were considered a violation of the dress code. In the workplace, black people with curly afros, braids, twists, or locks, or with no hair, are often perceived as less professional than people with straightened hair, which negatively impacts their ability to be promoted or to get raises. And yes, personally, I've always worn my hair however I chose. I've worn it straight, I've worn it braided, I've worn it spiked, I've worn it curly, I've worn it in a big natural, you name it. You name it. Everyone should be able to make those choices without fear of repercussion. Hair discrimination is rooted in systemic racism and is a real barrier to advancement and empowerment for our communities. Now, I've been fighting to end this discriminatory practice for years. In 2014, the women of the Congressional Black Caucus urged the Army to rescind Army Regulation 671, which prohibited many hairstyles worn by African-American women and other women of color.
Gentlelady's
and I led an
time
amendment in the
has
fiscal year
expired.
15 Defense Appropriations Bill to ban funding for this discriminatory rule.
Gentlelady will suspend.
May I have another 30 seconds? Mr. Chairman.
I yield the gentlelady another 30 seconds.
Thank you, Mr. Chairman. I just want to remind you, we put this in the Defense Appropriations Bill to ban funding for this discriminatory rule. The military understood it. And due to our advocacy, a few years later, the U.S. Navy removed their discriminatory policy, allowing women, especially women of color, to wear their hair in dreadlocks, large buns, braids, and ponytails. We owe it to ourselves and to future generations to take action here in Congress to break down these barriers. Everyone should be able to show up as their authentic selves, and passing the Crown Act is a major step in that direction. I urge my colleagues to vote yes, and I yield back.
Thank you, Madam Speaker. I just want to point out the Majority Leader just 3 minutes ago said the reason the bill is on the floor today is because of the minority. That can't happen. We don't schedule the floor. The reason the bill's on the floor today is because the majority is bringing it to the floor. I mean, I would love to be able to have the power as a minority to bring legislation to the floor, because if we could, I tell you what, it wouldn't be this bill. It'd be a bill dealing with energy, a bill trying to bring down the price of gasoline, which is at $5 a gallon in some states. It'd be a bill trying to deal with the border situation. I wish we could schedule the floor. Now, let's hope the American people are going to make a change this fall and put us in a position where we can schedule the floor, because if we do, if we get that power, we will focus on those kind of issues. The majority leader of the House of Representatives just said the reason the bill's on the floor today is because of the minority. That cannot happen. I wish it could, but it can't. Those are the kind of arguments we're getting. We should be focused on the issues the American people want us to focus on right now. Families across this country, all families, want us to focus on certain things, but not the Democrats. They're going to focus on the hair bill.
For 1 minute.
They're going to focus on
Madam Speaker, we need to protect the American people from corporate greed and abuse. The FAIR Act is one of those protections. Corporations use forced arbitration clauses to deny Americans their right to seek accountability and justice in disputes with private companies. They literally eliminated any chance a resident may have for justice from a dispute, specifically in the place of employment. From employee handbooks to bank accounts to documents to a college admission paperwork, companies include forced arbitration clauses as the main form of dispute resolution so that they can rig the rules and appoint themselves judge and jury in the arbitration process. Forced arbitration is a private, secretive system without any enforceable standards or legal protections for our residents. There is no public disclosure of proceedings or any requirements for arbitrators to follow the law. So, Madam Speaker, forced arbitration makes it virtually impossible for anti-discrimination laws, disability rights laws, and so many other important laws to be enforced at the federal level. To put it simply, this is unjust and has failed the American public for far too long. Earlier this year, President Biden signed a law ending forced arbitration for cases involving sexual assault and sexual harassment. So I urge the Senate to pass this legislation and send it to the President's desk so that we can protect consumers and workers from corporations that seek to exploit them. Thank you.